I have to be. I've got academy. It's like first day of academy. I need to go find. Well, why was it so early? I hate this. It's so early. I don't remember doing AU Academy than NA Academy because NA's at 3 AM and no, I'm not doing that shit. So I'll just wake up early for AU. I'm fucking freezing though, like I'm actually so cold. I'm hoodie on, like I'm still so cold, like I'm shivering. I need to scramble for food before we get to BBD. I'm hoping open arms. Like, you're bad. I don't mind being a bit silly, but it's just no, my favourite time, you know. Did I post a song? Oh no, he's doing that fucking weird ass fucking. I'm gonna have a break in the middle of a song for like 2 minutes before we start again. I'm gonna just skip that shit up. I don't actually know what to park.
Hey, you missed your training session. No le oigo bien.
Oh, speeder. I'm heading out all morning. Oh hell yeah. Go do normal human stuff. But loggers are so fucking weird.
Yeah, Lord, I'll ride with you anytime. So glad to finally have a day off.
It's actually on here. Actually, yeah, infinite. That's a second. I want all like fresh stuff. This shit is not fresh. Oh my god, there's so many sort of.
Mm.
What is the mystery tray thing?
Honestly, I barely work here. I have no idea.
Oh, okay. All right. What do you think? The family or the Tammy?
Do the family one unless you're super hungry.
All right. Can I do the family with 2 vegan burgers?
Yeah, perfect. That'll be fine.
You.
Oh.
Oh, he looks like he's going to jail. Also, looks like Lana has 3 sprites.
Did you want water or soda with?
Water, I believe.
Oh yeah.
4 waters. Cool.
I think unpopular.
Damn it.
Uh,
I think it's just because I'm cooked.
alright, on for you.
Thank you.
Oh, I can't be stuck here. Oh, what? People
There you go.
coming.
All right. You have a good day. All right, let's go.
Okay. Alright.
Hello.
Can I get what I want? Can I get the Yogi Corporate Terrorism Special? With all sodas, no ice, and ranch as the dressing, please.
Alright, so that's attendees and cool. I'm gonna be the world's fastest person because I need to go somewhere.
Oh, okay.
I have my academy, so I can't really stay here for much longer.
Oh
Alright.
my. I'll have to say that.
I literally came here to make myself food because no one was at Mega Shot and no one's here. And
Yeah.
I get stuck here, which is lovely. I hate it. but I have to do it. Right, cool. Perfect. That's that on the tray.
Alrighty. Thank you.
I'll have the same, just real quick.
I should have them. Alright, just missing one of your water.
Okay.
Alright, here you go.
Thank you.
No, good one. I have to fucking do it. I have 9 minutes.
Lord have mercy!
I'm going to start like running red or something to get there in time. It's basically in jungle right now. I'm pretty close, holy shit. Oh, okay. Fucking bagel shot on. There's a fucking. It gets told, you know.
Oh, okay.
Good morning. Just navigate to fucking. Howdy.
Hi, good morning.
I might put way too much.
That's good because I didn't bring any today. I forgot.
I'm playing Jenga. Do you need any food right now?
I don't need any right now. I probably will later, though.
I cannot fill.
I have no clue how long this is going to be.
Me either. I suspect like 3 hours ish. I tease them.
Level 2, 3. I think it was 3 that we're going to.
Yes, I believe so.
3. Yes, 3.
Nice. Okay. Ooh, that's easy.
Sitting's gonna be hard, isn't it? Maybe I'm just not gonna. That's how you do it.
Oh, perfect. Everybody's here. If you want to get any food or water, there's a food truck right outside VPD for you guys.
Yeah, we're gonna give it a few minutes before we start. If you need anything, there is a food truck out the front.
I'm good for now, but I'm probably gonna go down there for later.
Yeah.
Oh yeah, he's leaving in 10 minutes, so this is your child.
I don't know if it's gonna be scuffed or not. Yeah, it's so scuffed. Can I pop literally anything? I pop literally anything. I know I have literally no room to fix possessions in, but like we're not, you know, this is only academy, so like, fine.
Permission to make a phone call really quickly.
Yeah, go for it. We're
Thank you.
still waiting another couple of minutes. That was a very loud fire hydrant.
Very loud.
Well, it looks like everybody's turned up for the second day.
Nice.
Actually, how are we doing?
Dina, if you need any food or drink or anything, there is a food truck out the front. It's gonna be
Yeah,
another
that's why I
couple
was
of
a little
minutes
late.
before we start. Okay.
Sorry.
Wow, we actually have the LSPD in the city, and Alice is the
Must manage,
insanity
yeah.
right now.
Yeah.
There's a lot more LSPD.
Skylar. Oh, hey, Bloom.
Hey.
Bloom.
Hello.
Are you enjoying not being command?
I got fired.
It would.
Yep.
Got fired from being command. I don't know if it's a pog or such.
Anyone else want one of my stripes while they're at it? Anyone in this room? I'll give it to them.
Yeah, split it in half. I'll take the other half.
This is because you didn't talk to me, Meyer.
Oh!
This is because you didn't talk to me.
What?
Yep.
Wait,
Is it
what?
because you can't fire me? You got fired?
Oh, he's not fired.
This is because of you.
What he said though, he said he's fired. Ooh, alright.
Congratulations on the
Congrats.
third stripe, Lana. Yeah.
Thank you, Stokes. Appreciate it.
Yeah.
Appreciate it.
Alright, we just wait for Mateo to get back from the food truck and then we'll get this started. In the meantime, everybody take a seat. Okay, a seat on one of the blue chairs. Come on, you're part of the class.
Who's gonna sit on top of mine?
Yeah, that looks really comfy.
Just stretching out the hammies, you know?
Yeah, I respect it.
We do this with every class.
I hate these
And-
chairs.
Yeah, people struggle with it.
Yeah, I'm struggling. I'll be honest.
Just sit down.
Yeah, just sit down, guys.
I'm like glued to the floor.
No.
You gotta take a seat.
We'll be here for a few minutes, so like, just see guys. I might pop something like, I'm gonna say chill on, because it's not chill, but like, you know, I need music for this.
Yeah, that's close enough. God, people are really taking their time down on the food truck.
Must be a long queue.
Is that the only food truck around? Probably are. There's a sushi place outside City Hall.
Oh yeah, no, that's the one for
That's this one.
Oh, okay.
They moved over here.
Oh my god. I need to add this to my I need to add this album to my playlist. Like that.
I'm gonna pop downstairs.
Oh my god. Yo, poggers, thank you. I might just update my follower. I've what, Agent 20.
Meyer did this.
What did I do?
Are you eavesdropping over here? So shut up.
Oh,
What the fuck?
I have 6 subs. I think.
Alright, Mateo's just behind me. Alright. Take a seat, Mateo, and we get started.
Why is there a
I'll
divide?
try.
Two sergeants.
This thing on?
Yeah.
Yep. Okay. Hey, everybody. My name is Lana Gray Quinn. As you can tell by the uniform, I'm a part of the Los Santos Police Department. I just want to say I'm happy to see all your faces here. Really just want to introduce myself, and if you have any questions or concerns and you can't reach out to somebody else, my phone, I'm available nearly 24/7, okay? So I'm going to share my number with y'all, and whether it's for an FTO session, a ride along, or just want to chat and meet somebody and get to know someone in the PD, I'm here for you. So just jot my number down, and that's really it.
Are we introducing ourselves?
Yeah, you want to introduce yourself, Bloom?
Did you send it?
Yeah, here.
Oh.
There you go. Did everyone get that? Oh,
Thank you.
hey.
Does it even matter?
Yep.
Does it even matter who I am? I
Oh
mean,
my god.
does it even matter? I mean, that's the point, right? Is that we all have each other's back regardless of who we are. Regardless of uniform, rank, doesn't matter. Doesn't matter if Meyer stabbed me in the back. Doesn't matter if she ruined my life.
He's so dramatic. I
I'll
love
still
it.
shoot someone if they threaten her life.
Good.
And I won't even hold it over her head. My name's Bob Smith.
Thanks, Bob.
Nice to meet you, Bob.
I'm pretty sure you introduced yourself as Sergeant Bloom at the thing.
That's impossible. I'm not a sergeant.
Yeah, Sergeant Bob.
Sergeant Bob. It sounds
Bob.
like
Yeah, Sergeant Bob. Hell yeah.
All right. Well, today is going to be mostly a classroom session. We're going to go over a lot of the basics with police work. So it may be a little boring at times, but please stick with us. Please pay attention. You know, we're going to be going over a lot of concepts here and a lot of things that you'll need to know on the field, okay? And just like any other time, if you have any questions whatsoever, ask them. Okay? This is your time to ask questions. We are here to help you with anything you need. Alright. Yeah, Josh?
One question that might be jumping ahead, but I've read in the document we do the auxiliary hours whenever you're security, right? Is that after the whole academy, or could we do it between when we are waiting for the
It
next
is
academy?
after academy.
Okay, got it.
So yeah, after academy you'll be able to do those. We will go over those in more detail tomorrow because you know that's the end of academy. But yeah, definitely at the end.
Okay, thank you.
All right, how we doing?
Good.
All right,
Pretty
how are
good.
you?
Mm-hmm. All right, we're gonna start with the basics of policing. Can anybody tell me what RS is?
Reasonable suspicion?
Mm-hmm. And what is reasonable suspicion?
Well, you think a crime is, possibly being committed?
It's a
It's a guess.
It's a presumption that a crime is being committed, has been committed, or will be committed. It's based off facts and circumstances. It's more than a guess, but like less than a hunch.
Mm-hmm. Yeah, so reasonable suspicion is a reasonable presumption that a crime has been, is being, or will be committed. It is a reasonable belief based on facts or circumstances and is informed by an LEO's training and experience. Reasonable suspicion is seen as more than a guess, like you said, or a hunch but less than probable cause. Having reasonable suspicion is ground for detainment, but not search and seizure. Now, you can do multiple things with RS. Can anybody tell me what those are?
Detainment.
Mm-hmm. Mm-hmm.
Well, I guess detainment would require questionings.
Mm-hmm. One more. Let's say you arrive on the scene of a shots fired call. You have somebody detained, matching the description.
GSR.
How are you gonna determine if they were the shooter or not? Mm-hmm.
GSR.
GSR.
Testing, yeah.
Mm-hmm. Alright, so let's break it down. So, a detention is a brief or cursory holding and questioning that is based on reasonable suspicion. Detention must last no longer than necessary and must be conducted with the least intrusive and reasonable available means. So when you're detaining an individual and you want to question them, make sure to read them their custody rights first, before asking any questions that might be self-incriminating.
Need
Does
to
anybody...
get that line updated.
Yeah, I just saw it, so sorry. Alright, can anybody give me the custody rights?
You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney or a bench trial. If you cannot afford an attorney, one will be appointed to you by the state of San Andreas.
Mm-hmm. Yeah, or...
So, a little interesting fact. The bit about not being able to afford an attorney is not part of the custody rights.
Oh.
Yep.
Mm-hmm.
So, obviously you can word it as you like. The main parts that are required is they have the right to remain silent, and that if they waive that right, anything they say or do can and will be used against them in the court. They also have the right to an attorney and the right to a bench trial if available. That's it. So as long as you incorporate all of those things, you're good.
Oh.
Mm-hmm. Or my favorite version is you have the right to shut the fuck up, you have the right to representation, you have the right to a bench trial. Yeah. But just, you know, keep it professional out on the field.
Okay.
Alright, so. LEOs can ask for detained individuals to provide identification to run background checks and determine if they have any wants or warrants. Attempting to leave or resist detainment may be grounds for arrest, aka resisting arrest. LEOs may place a detained person in restraints if the LEO has reasonable belief that the individual that has been detained or will be detained is a danger to themselves, LEOs, or other individuals, or if they believe that the individual will attempt to flee. LEOs may frisk a person who is detained for their own safety. Discovery of any illegal weapons may be grounds for arrest.
I don't know what's that about.
And then, of course, you may GSR test an individual. Alright, so now we've gone over RS. Does anybody know what PC is?
Probable cause?
Probable cause.
And what is probable cause?
It's hard evidence that, somebody's committed a crime. A logical belief that, facts, circumstances that a crime has been committed or is being committed.
Exactly. So, probable cause is having sufficient reason based upon known facts to believe a crime has been committed or that certain property is connected with a crime. It's the logical belief supported by facts and circumstances that a crime has been, is being, or will be committed. PC is enough for... what can you do with PC?
Arrest.
Search and seizure.
Yes, those three things. So you have with PC, you can obviously do anything you can do with RS, but you can also arrest, search, and seize. Alright, so for arresting, The taking of someone into custody through a significant restraint on movement, including but limited to placing handcuffs or restraints on that person. That's what an arrest is. Arrests are made using probable cause. If not
Crazy,
already
man.
physically restrained, individuals will be remanded into custody with the least force possible. So, Elios must make the individuals aware as to why they have been arrested as soon as possible. Elios are advised to not ask questions related to an incident other than the identity of the suspect if they have not been read their custody rights. Same as with RS. If you're gonna ask them any questions related to a crime, read them their rights first. Otherwise, it's gonna get thrown out in court. Individuals placed under arrest may be searched and contraband seized. If you are the arresting officer, aka who placed the person in cuffs, you are responsible for the individual you've placed in cuffs. If injured, the arresting officer must ensure the suspect receives medical treatment. As an LEO, you are required to provide a suspect with an attorney upon request. Likewise, if a subject requests a bench trial, you must contact the judge to conduct a bench trial. Now, this might also be a bit different from what you might be used to, but if somebody requests a bench trial, let's say for a warrant, you are to request a bench trial and explain to the judge why you think it would be a bad idea to do a bench trial. So let's say the witnesses aren't available, the primary officer isn't available, but in the end that decision is going to be from the judge and not from you. So always request a bench trial if it's requested. Mm-hmm.
Alright, has anybody got any questions on RS and PC at all?
No, man.
No, nothing? Okay. So next up, search and seizure. So there are 2 reasons that you may search a person. Can anybody give me one of those?
Consent.
Yeah, consent. Perfect.
And probable cause.
Probable cause, yeah.
Yep. All right. Perfect. Yep, those 2 reasons. For these, I just yell out. Don't bother putting your hands up. All right. Vehicles. Can anybody give me reasons to search a vehicle?
Consent, probable cause, arrest. If you're
Legally
impounding a
impounded.
vehicle,
Search warrant.
And a warrant, yeah.
Okay. Yep. All right. We hit on nearly all of them. There is one more.
the vehicle's being impounded.
You said that one.
The arrest and the search is like related to the arrest.
Said that one as well. No, one is resulting from a canine sniff.
Oh. Yeah.
That makes
True.
sense.
So, obviously, you know, conducting a traffic stop and a canine sniffs the vehicle and indicates that there may be contraband in the vehicle, you may then search that vehicle, find that contraband. All right. And for properties, we've got 2 of them here.
Consent.
Search warrant is approved.
Yeah, that's it. There's only 2. And I am so glad that you guys said consent for all 3 of them. It is the one that is missed most often. It
They were
is
just
the
all
most
looking at the
important
sheets.
one. You can use consent to do so many things. So, you know, ask people. Ask people if you can do things. Maybe you want their DNA to rule them out of something. Ask them. You want to search them? Ask them. Some people like wonder like why you're asking them, but there's never anything wrong with just asking somebody. All right, next up, we've got a bunch of case laws. Maya, do you want to take over this section?
Yeah, sure.
Did anybody have any questions on the searching at all? Okay. Take it away.
Hey, I'm going through some case law. We have a lot of case law in our state, but the ones that are relevant are as follows. There's the custody rights, which were spoken to you already by senior lead officer Meyer. Any statement, so it's Gage custody v. the state. It's basically the we have our sister states, they have Miranda rights. In our state, we call them the custody rights. Any statement made contrary to a citizen's Article 5 rights, which is the right against self-incrimination, must be made voluntarily and knowingly. Article 5 and Article 6 rights attach when the individual is brought into the custody of police, which is the beginning of the adversarial charging proceedings. Basically, once they're brought into custody, they're in a police-dominated environment, and their rights must be read to them. So is the right to remain silent. Any statements made may be utilized against them in the court of law. Right to have an attorney present during any questioning and through the charging process if one is available, and the right to contest any and all charges pressed against them at a bench trial, provided there is one available. A bench trial is not available when a judge, for a few reasons. So first of all, a judge is unavailable. You request a bench trial no matter what the situation. The suspect says bench trial, you put a bench trial request in. If the judge doesn't answer it, then sucks for them. The judge is just simply unavailable. Or when witnesses are unavailable due to injuries that occurred either during the underlying incident or any other incidents which stemmed from it. Basically, what that means is, Mike, you pull over Mike Block. Probably never happened in shift 3, but you pull over Mike Block at a traffic stop. He flees. I don't know, one of his boys in the blocks also comes in and interferes, and cops start chasing that, and then it turns into shootouts. So Mike Block starts shooting at cops, and his boys pull other officers away from the main pursuit and also start shooting at cops. And I don't know, you shoot them down, but you have 2 officers who were the main officers, the ones who initiated the traffic stop, for example. They're in the ICU. Because they're in the ICU, the full facts of the case aren't available to you. And basically, a bench trial can't really proceed. You'll still put a request in, you'll let the judge know of the circumstances, saying they want a bench trial, but all of the main officers involved were injured from it and they're in the ICU, and the judge will likely tell them to take it to an appeal. And the last part, any statements made to peace officers during the course of a custodial arrest prior to the issuance of the above custody warning shall not be considered knowing or voluntary statements. So say you arrest someone and you don't read them their custody rights, you question them and they tell you a bunch of incriminating stuff, guess what? Those statements are not considered knowing or voluntary statements. And their admissibility in court will be called into question. Most likely it will get stricken out, but yeah, it will be something that gets taken to court and you'll have to explain yourself to the judge. Next case law, we have State v. Grandmire. State v. Grandmire is 2 parts. We have part 1, which is your equivalent of Carroll v. United States. A readily mobile vehicle, or one that can be made readily mobile in a brief period of time, may be searched by law enforcement without a warrant upon a showing of probable cause that the vehicle contains contraband or evidence of a crime, provided that the vehicle is located in a place where law enforcement have a legal right to be. That's the first part of State v. Grandma, is your car v. US. And then the second part is relating to drugs. Officers have probable cause to perform a search of a suspect for drugs, drug paraphernalia, or contraband in circumstances where 1, the officer would be entitled to perform a moody frisk of the suspect. We'll explain that in a moment. And the suspect attempts to flee the area upon notice or arrival of law enforcement. We'll explain the moody frisk later, but the circumstances relating to you arriving at the scene of suspicious activity, find you witness a handoff or take evidence of a handoff either through photos or you witnessing yourself, and you're arriving on scene. The suspect then attempts to flee. The circumstances around that brings it up from reasonable suspicion to probable cause to then search them. Are there any questions about those first 3 case laws? Because it is a lot when you look at them for the first time. Yeah.
For the custody rights one, when we arrest them, do we read them the rights at the the cells, or could we do it once we cuff them up as well, or when we're taking them?
Yeah, you can do them on scene when you've cuffed them. You can do them. You can read them in the car as you're transporting them to a police station, or you can do them in the cells. Obviously, the earlier you do it, the better, because any statements that they do make would be known and voluntary from that point.
Right. Yep. Got it.
Yeah. Any other questions?
What was the last case law you were talking about? What was the name of it again?
State v. Grandmire.
Good.
Yeah, it's a bit of a...
I want to quickly go to Maybe Cummins as well, because it's very related and he's not in this list.
Oh, wait, it's not?
No. Might need to get it added to the list.
I'm guessing the state we grab is talking about the RVs, right? It's like
It's broken up into 2 different sections. So it's, yeah, pretty much it covers searching of an RV as well as the PC to conduct a search on people for drugs.
Okay, got it.
Yeah, the RV part is one that can be made mobile in a short period of time, because it is very quick for someone to go to an RV, detach any of the what's it called, cables for it, the water, the electricity, and pack it up in a short period of time. Because it can be made readily mobile in a short period of time, State v. Cummins does apply. As for State v. Cummins, in any situation where law enforcement would have reasonable suspicion to stop and detain a suspect for further investigation or questioning, the odor of marijuana about the suspect, in combination with the factors that created reasonable suspicion for the detainment, gives LEO's law enforcement sufficient probable cause to perform a warrantless search of the suspect's person for drugs or drug paraphernalia. Might seem like a lot, but it's like a couple of checkboxes, if you will. You arrive on the scene and you have reasonable suspicion to detain a suspect. That's checkbox 1. Checkbox 2, whilst you have the suspect detained, you notice that
it's gonna be a lot of information,
notice the odor of marijuana
of
around them, the smell of weed. That's checkbox 2. Once you hit both of those checkboxes, a search
to most of them be more
the
fun.
suspects for drugs or drug paraphernalia can be done. That's the easiest way to break down Stevie Cummins.
Yeah, it's a very powerful case law, and it's something that honestly during this shift we use a lot because we get a lot of drug calls. So you know, you respond to a drug call, you got somebody fleeing from it, maybe they stop for you. You know, you order them out of the car, have a bit of a sniff of them, maybe they stink of weed. You now have grounds to search them for those drugs.
One thing that you don't do with State v. Cummins is this. I'm going to go to the up and atom for no reason whatsoever. I'm gonna walk around. Oh, hey, Stokes, you smell of marijuana. I'm not detaining you. No, don't do that. You need reasonable suspicion to detain first. Don't go running around public places and sniffing people for weed. Don't do that. That's silly. Okay?
Yeah, weed's legal. Everyone's doing it. Or almost
Yeah.
everyone.
Weed, not legal, decriminalized. I don't say weed is legal, it's decriminalized. You can, anyone can carry up to 3 grams of marijuana, either in dried marijuana form or as joints. Any more than that,
So-
then they're in. Sorry.
Yeah, the reason we call it decriminalized is because while it is legal to carry up to 3 grams, it is not legal to give that marijuana to anybody else. It is not legal to grow it. So it's technically not legal because, you know, you can't actually obtain it legally. So it's a very, very important distinction.
Right. Any questions on those case laws before we move on? Because there's a lot more.
One thing that I
Alright.
do want to make very clear is, at least in my shift, we're not going to test you on the names of these. The idea is that you know them and can use them. Knowing the names is a bit irrelevant. As long as you can articulate why you've done something, that's all we care about.
Hey, more case laws. Gasper v. Meyer. It's her. A case law. Is basically the equivalent of Terry v. Ohio in our sister jurisdictions. Law enforcement officers may detain and frisk suspicious individuals on the scene of a crime that is violent in nature without probable cause to effect an arrest. This is provided that the officer has a reasonable articulable suspicion that the individual may be in possession of material evidence that may be extracted from the scene. For example, I think in this situation it was at the Clucking Bell, right?
Mm-hmm.
Yeah. Reports of shots being fired at the Clucking Bell. Officers arrive on scene. You may detain and frisk suspicious individuals on that scene without probable cause to effect an arrest, because there you would have a reasonable suspicion, a reasonable articulable suspicion that the individual may be in possession of material evidence that may be extracted from the scene. A gun, for example, a gun that was used to shoot. That is material evidence that can be extracted, that's easy to move. You'll have reasonable suspicion to frisk that individual for that gun. Moving on, State v. Pantalones. You remember when Stokes was talking about reasons to search a vehicle? One of them being inventorying vehicles for impound. We have a case law for that. It's State v. Pantalones. When an officer has a lawful reason to perform an impound on a vehicle, the officer is able to carry out an inventory search of the inner and outer compartments of a vehicle. This must be documented at the time of the search, and the person in possession of the vehicle shall be responsible for any illegal contents found during that search. So, for example, you are, I don't know, let's think about this. City Hall and they're parked on the sidewalk. Because they're parked on the sidewalk, that is unauthorized parking. That is a reason for the vehicle to be towed. You can perform a search of that vehicle to document the inner and outer compartments, basically your glove box and your trunk. And then, yeah, anything that you do find will be responsible of the person who was in possession of the vehicle at the time, which is usually the driver. And I don't think what else there is for Stevie Pantalones. That's pretty much it, right? Stevie Pantalones. All right, next case law. The People v. Donald Ashford. I have no idea why it's written differently to everything else. Most of our case laws state. This one's the People. The People v. Donald Ashford. Hot guns. You know what a hot gun is?
Okay.
And used in the commission of a crime.
What do you mean by using the commission of a crime?
It's been discharged.
It's been used in a way that is not legal, or in the act of a crime.
Okay. Yeah, so if a person is found to be in constructive possession of a weapon or a firearm that can be identified as being used in the commission of a previous crime, this is our quote-unquote hot gun, that person shall be subject to all charges that can be proven beyond a reasonable doubt which are tied to that weapon or firearm. To prove their innocence in such a case, the burden of proof shall shift to the defense, where they must prove based on a preponderance of evidence basically 51%, whether it is more likely than not that the person was not the perpetrator of the crimes. So, I don't know, you arrest someone for theft of a motor vehicle, search them, you perform a search of that person, they have a B92 handgun, you run the gun at the police station, you find it comes back to 2 cops shooting. As part of charging them for the quote-unquote hot gun, you don't take a look at what that person has done in relation to the incident. You take a look at what the gun has done. That gun was used to shoot cops. You charge the person who had that gun with the attempted murders of government employee, with the attempted murder of a government employee. And for them to prove they have to prove their innocence in that instance. So they would go to court. They would basically explain to the judge, based on a preponderance of evidence, more likely than not, that they didn't shoot that gun and attempted to shoot officers. They've got to prove that in court. All you have to do, what the district attorney's office has to do, is basically say, this gun was used to do this shooting. Right? Any questions? Okay, State v. Moody. This was one that I touched upon earlier in State v. Graham Meyer. This is basically a Moody frisk. When a law enforcement officer is directed to a location due to a cat alert, basically a dispatch call, indicating suspicious and anonymous tip, 911 call, other alert, which tend to indicate the sale of drugs based on the training and experience of officers. And police present evidence in the form of a photograph or testimony of suspicious handoffs by a citizen observed on location of the first. A police officer may stop a suspect on the street and frisk him or her based on the reasonable articulable suspicion formed by the combination of the above. It's another checkbox case law. You go to a dispatch call, either a dispatch call of suspicious activity, or you respond to like an anonymous tip or a 911 or another alert, which would tend to indicate the sale of drugs based on your chain of experience. That's checkbox 1. Then checkbox 2 is you arrive on scene and you can present evidence in the form of either a photo of a suspect performing a handoff, a suspicious handoff, or your testimony, you witnessing a suspect performing a suspicious handoff on location. Once you achieve those two, once you tick those 2 boxes, you can stop the suspect and detain them. You can also frisk them based on that reasonable suspicion. And yeah, we go back to Stevie Grandmeyer. Stevie Grandmeyer expands on it in the fact that, hey, if they attempt to flee, because of them attempting to flee in the eyes of the court,
they didn't leak.
Most likely than not, that they're a guilty person, they attempt to flee the scene. Once officers arrive, that would then arise the probable cause to then search them. Alright, that's how Grandma links into Moody.
Oh yeah.
Any questions on Moody frisk? Oh, you had your hand up. Sure.
I'm going to nap soon. Hell yeah. It's like what, 5 PM for you?
I don't have a picture, but I witnessed it. Is that good enough, or do I need someone else to witness it?
Oh no, yeah. If you witness the handoff, yeah, you witness the handoff. That's your. Yeah, you've checked.
Officer testimony is like one of the highest things the judges will take.
Yeah, it's completely yeah. It'll be completely unreasonable for the judge to say you didn't take a photo of this handoff. Did it ever really happen? The officer testimony is enough.
Okay.
All right, let's move on to State v. Glenn Armstrong Jr. is basically sister jurisdiction equivalent of Tennessee v. Garner, where the officer has probable cause to believe that a suspect poses an immediate threat of serious physical harm either to the officers or to others, basically members of the public.
A lot of case laws.
It is not constitutionally unreasonable to prevent escape by using deadly force. Suspect threatens the officer with a weapon. There is probable cause to believe that he has committed a crime involving the infliction or threatened infliction of serious physical harm. Deadly force may be used if necessary to prevent escape. and if, where feasible, some warning has been given. Sounds pretty self-explanatory when
My voice.
again,
Wait,
when
my voice is
you,
quiet.
officer,
Oh,
is
hello.
faced with a suspect with a firearm, with a
Is it-
weapon, not even,
Am
not
I
even a firearm, just
better?
a weapon, or there's probable cause to believe that he's committed a crime involving the infliction or threatened to
Wait,
inflict
am
a
I
serious physical
louder
harm.
now?
You as an officer can use deadly force
Because
if
my mic
necessary
wasn't
to
all the way
prevent
up.
escape.
It's a bit better.
And
Like,
where,
how
if
better?
feasible, some
There we
warning
go,
has been
okay.
given. Yeah, try and warn your suspects, please. Yeah, if you are in a foot pursuit with someone,
I mean, I can
with a
turn a
firearm, with a
game
weapon in
down.
hand, do warn them, hey, stop now, or hey, put the firearm away now, or the weapon away, or else I'm going to open fire on you. That's your warning to the suspect. Or you give them the
I'm looking forward
opportunity
to tomorrow
either
because it's like
surrender
traffic
or
stops and
put their
pursuits in
weapon away.
VR.
If they fail to do so, you can use deadly force.
I am excited for that shit.
So to have more on that as well.
And then we're done.
Obviously, in that
Bro, the
scenario, if
evidence
they
shit is
turn
so
around
fucking
and
cool.
point that gun at you, do not hesitate.
Shoot them. Yeah,
Put
okay,
them
just
down.
shoot them.
Like in that case, no warning is needed. They have pointed a gun at an officer. That's it. Put them down. This also applies for other deadly weapons. Like if somebody, has been threatening people with a bat, maybe hitting some people with a bat, you are within your rights to invoke State v. Glenn Armstrong Jr. against that person.
Yeah, if a guy is fucking running at me with a baseball
While
bat,
it
I'm
is
shooting
just
them.
a bat, it's not a firearm. They can still kill people with it.
Exactly.
All right. Anybody got any questions on any of those?
What's a good amount of warnings to put the fucking gun away?
One or two, like.
Speak up, Dina.
What's a good amount of warnings to tell them to put the gun away? Like a few, once,
legally once, but ideally, give them a few chances. If they still don't comply, then you're within your rights. But legally, you technically only have to give one warning, but I would prefer you give more. It all depends on the situation. If somebody has posed a very
This is like the
clear
first ever time
danger
I'm also
and
in academy as well.
very clearly not going to give up.
Yeah, this is the first time I'm
then
in
you
academy.
obviously
I've
treat
never
the
done
situation
one in no
differently.
pixel. Like
every situation is
never did one
fluid
in no
and you need
pixel,
to
and I'm
adapt to
happy
it.
I can do
There's
academy
no set
here.
number of okay, you need to give them 3 warnings.
I don't feel like
it's
I'll struggle.
It's dependent on the situation.
Be honest, like I don't feel like I struggle at all.
Okay.
Maybe I will. I don't know.
All right. Anybody else got any questions? Left side of the room over here has been very quiet. Olivia, Maisie, you two still awake?
Oh yeah, I'm good.
Okay.
Taking some notes.
Fair enough.
Actually, I got one more thing for case laws. Hey, MDW is great. If you go to your MDW and go to documents, so if you go on the top left, you know how to slide the 3 bars. If you go to documents legislation, our DOJ is great! Exclamation mark. Case laws. They're on the MDW.
Oh,
perfect. Yeah, you
perfect.
take a look
Oh,
through.
perfect.
Yeah, this
Okay,
is
thank you.
yeah, this is a list of every single case law in our state that
Oh
are
my
active.
God.
Obviously, there are more case laws than what we've gone through today. If you want to read up on those, you can. But the ones that we did speak about here, shown on board, and they're your main ones.
There's so many. I'm gonna VIP you, Leak. If I have any slots, I'm gonna VIP you.
The vast majority of the time on patrol. However, obviously, there are.
Can I VIP
more.
you? I can. Pog.
As I said earlier, we don't care if you can name them all. It's irrelevant. The idea is that you can execute them. All right, Leon, you want to go over some use of force? know, Josh, you need to run in a bit. That's fine.
Yeah. I should be soon. You'll know when I just run away.
Yep, all good.
All right. Hello, everybody. First off, I want to thank Senior Officer Maya Mahmood for being here, and that was great. That was great.
Fucking.
Hello, everybody. It's me, Deputy Leon Jericho, Corporal Leon Jericho, however you want to call it. I'm here to talk to you guys today about the use of force continuum. Okay. This is going to be the amount of effort required by law enforcement officers, that be you, to compel compliance of an unwilling subject.
Pog.
Okay. We're going to start with level 1. That's going to be officer
I
presence.
am. There's a lot of information though. Like.
Officer presence. No force is used. All right. Subjects are obedient, compliant, and non-aggressive. The mere pressure of the officer works to deter crime or diffuse a situation. Officers' attitudes are professional and non-threatening.
My case laws are always been the weakest thing of me anyway.
Officer
so, like,
presence. Can anyone tell me what that means? Or give me an example.
Just being there.
Just being there. Okay.
I just existing.
Skylar?
Let's say there's like a bunch of people who are like having like an argument, they're screaming and shouting, and it's like kind of like, are they gonna do something? If we just kind of like show up and stand around, then they're less likely to do anything because there's police presence there.
Anyone tell me what's a good indicator of officer presence?
The car or our patrol vehicle or the
Yeah.
uniform we're currently wearing.
Yep. What about our patrol vehicles?
The lights.
The lights are on.
The wee-woos, right?
Wee-woos,
Right? Yeah, the wee-woos, the flashing lights. Yeah. Those lights, those sirens, that's a form of officer presence. Us arriving to a scene, right? That's one of the examples. We're gonna go over level 2, which is verbalization. Force, not physical. Subjects are obedient, compliant, and non-aggressive. That being the suspect or civilians that you deal with. Officers issue calm, non-threatening commands, such as, let me see your identification and registration. This is especially used during traffic stops. Hey, can I see your identification and registration in the vehicle, proof of registration, right? Officers may increase the volume or shorten their commands in an attempt to gain compliance. Short commands might include stop, don't move, freeze, or in my case, please. This is an example of using our most powerful tool, which is our communication.
Wow,
yes,
communication.
Ladies and gentlemen, the best tool that the police department has is communication.
Sure,
Remember that one. Please note it down.
Yes, I.
Officers may attach repercussions for failing to obey a command, such as stop or I will place you under arrest. I want to see some hands on this one. Can anyone give me an example of such, like a command you can give a suspect? Yep. Yeah, in the back.
Oh, sorry. I said leave the area, please.
Okay. All right. Well, can I add something to that?
Yeah.
Leave the area, please, or I will arrest you. Let's hear that. Let's try that.
Leave the area or you're gonna get arrested, please.
Perfect. You don't have to add the please. That's just my kind of thing. But yeah,
Yeah,
for sure.
I didn't want to, but you did it, so I
You
felt
know
like
what?
I had to.
You know what? I appreciate that.
Okay.
I appreciate that. Can anyone else give us an example of such? No? Yeah.
Can you get out the car, please?
Oh well, I don't want to get out the car.
Well, now I'm gonna give you lawful order to step out the car. Please.
Yeah, I don't want to.
Well, now I'm gonna tase your cheeks out of the car.
Okay. So
Whoa.
let's go over that, right? So you told me to step out of the vehicle. I told you no. Now we just went over, right? that we can attach repercussions for failing to obey a command or a lawful order. All right, so let me put a wrench on that and
I'm gonna
add
go
a
open
little
blinds. 1 second,
nuts and
chat.
bolts there and say, step out of the
Wow.
vehicle. You are detained, or hey, do you want to speak on the sidewalk? Something like that. And I can add, if they're being uncompliant at that point, I can add something like, all right,
Yeah.
well, if you don't want to step out of the vehicle, I am going to be placing you in cuffs for X, Y, and Z, right? Does anyone have any questions on the first 2 levels of the Force Continuum? No? All right. Move on to level 3. Empty hand control, or in Japanese, karate.
Okay.
Officers use
In weeb.
bodily force to gain control of a situation. Subjects are resisting and not compliant. So the subject, or in this case, the suspect, same thing. Suspect, let's say that same example that we used before of the traffic stop. You told them to get out of the vehicle. They get out of the vehicle because you said, please. You're presenting them your reasonable suspicion, which you just learned about, right? And for some reason or another, they just decide to say, no, you're a pig, punch you in the face, and they run.
Oh my god.
Right? So at that point, if a suspect is resistant or not compliant, we can use soft techniques. Officers uses grabs, holds, joint locks to restrain an individual, or some people call it jiu-jitsu, or something in one of those countries. I think in Brazil or something. Shout out to Brazil. There's also hard techniques, such as, hey, in that same scenario, I described that the suspect punched me or punched
Oh,
one
I'm
of
beating
y'all.
him down with a
So I
nightstick.
can punch and kick back to restrain the individual. Does that make sense? Mm-hmm.
Yeah. Mm-hmm.
I hope so. All right. Level 4. Less lethal. Less lethal methods. Officers use less lethal technologies to gain control of a situation. Suspects are physically aggressive, and there is an immediate likelihood of injury to self or others. Blunt impact. Officers may use a baton or projectile to immobilize a combative person. Okay. So should I go over the other 2, or I'm just gonna go over the baton? So right here, the baton. Can anyone give me an example on when would it be best for you to use a baton?
If the person is trying to tackle or try and actively harm you, or say like punch you.
Mm-hmm. Okay.
Like he's trying to hurt you, but it's not gonna kill you, yes. But it's enough to hurt you, so that's where you use a stick basically, or baton.
What is the point of using a baton, Prime?
It's to immobilize them, to stop them, or I'll say, yeah, to stop them from like punching at you, to put them down basically, I'll say.
Very good. Okay. I don't believe we have any chemical, but just in case, chemical would be like a chemical spray, such as pepper spray, or like a beanbag shotgun, or energy
My
devices.
baby's
Let's
dying.
say, what's a good example of an energy device, Stokes? Do you have one? Oh, there it is. Oh,
Yeah.
Adrian Book's favorite. You guys ever see Sergeant Stokes and Officer Adrian Book in the same room? Be prepared to see live examples of this. Taser. Can anyone
Baby's
give me
dying.
an example on when to use a taser? This
If
is going to be a very
someone-
important subject here.
If, like, say you're in a